This is Law Talk, a public interest program of the Southwest Louisiana Law Center and CBS Lake Charles. I'm Mark, the Director Judson.
Jonathan Law Dog Fontenot from the Marshes of Cameron Parish.
And from the courtrooms of Calcasieu, this is Law Talk. Today's subject, powers of attorney. Pros, cons, and, well, professional cons.
Powerful powers of attorneys. What can you do with a power of attorney?
Well, power of attorney is what in Louisiana we call a mandate. All right, it's a voluntary grant of authority. So if I want to put you in charge of my affairs, or I want to entrust you or anyone to sign my name in my absence, I can sign a document before a notary and two witnesses and grant you, who I would call my agent, to be my power of attorney. You would literally have authority to act in my behalf, to do almost anything under the sun, or whatever the grant of authority that's contained.
Can I withdraw funds from your bank?
Yes, you could.
Can I pick up your prescription meds?
Yes, you can.
Do you have any I could borrow?
No, I don't.
Do you actually sign your name, or do you sign the person's name that you're...
So the power of attorney has to be executed by the principal, the one granting the authority. It has to be signed before a notary and two witnesses, and the agent has to sign to accept it. Now, when the agent is acting on behalf of the principal, the agent usually signs his own name, unless the person accepting the power of attorney requires something different.
So it's not a judgment from a court, it's just signed by the mandatory. Does a bank have to listen to it, or does a hospital or whatever have to, are they bound by it?
Do banks have to do anything?
Right, banks are their own.
No, no one has to accept a power of attorney. Anyone can refuse. Anyone can say, "Listen, I'm sorry, but I refuse."
It's not our policy.
Yeah, we don't deal with powers of attorney. We do not accept powers of attorney in real estate matters. Almost any bank or mortgage company, they will be very particular about their powers of attorney. They'll want it to have legal descriptions of the property. They'll want it to be no more than 1 year old or 6 months old. So powers of attorney are not automatic. They're not set in stone. They can be revoked at any time, and they don't have to be accepted. They can be refused by the person to whom they are presented.
They still are effective. They're still good to have?
They are wonderful to have, because what happens if you're in a, God forbid, a horrible car wreck?
Call me. Carl.
Right, well, yeah, that's right. No, but if you're in a car, if I'm in a car wreck, I can't call you because I'm comatose, you know. Okay. So if I have a sudden illness, or I suddenly disappear, or I suddenly become infirm where I cannot sign my name and have my own capacity, it is a wonderful convenience for the family, for a surviving, or for a spouse.
I can still do things on your behalf. Right. Get your energy.
And remember, the power of attorney is only good so long as the principal is alive. It only works while the principal is living.
So it's ineffective when you die.
Right. When the principal dies, no more power of attorney.
Remember the old saying, power of attorney is for the living, wills are for the dead.
That's right. That's exactly how it works.
Well, thank you.
We would love to have your legal questions. Go to the QR code right here. Send in your legal questions to Law Talk. We'll field your legal questions in future episodes. This has been a public service of the Southwest Louisiana Law Center. For Jonathan the Law Dog Fontenot, I'm Mark, the Director Judson. You've been watching Law Talk on CBS Lake Charles.